Good afternoon, everyone. Thank you for joining us. We're going to get started now. My name is Richard Smart. I am the Deputy Court Administrator in the Juvenile Section of the Family Division of Third Circuit Court. And we're happy that you joined us this afternoon for what we believe to be a monumental day in the history of juvenile court. I'm just going to lay out the groundwork for this webinar, and then I'll turn it over to our the two presiding judges of the Family Division. First, let me tell you give you a little background of what this webinar, the origin of this webinar, and why we're presenting it today. As you probably know, we've been working very hard to make both the domestic relations section and the juvenile section one family court, which has been our desire, and it's been very difficult for us to do so. And we've tried many methods of trying to bring the two sections together, one of which is for the juvenile court to handle many custody matters. And we've been attempting to do that now, but now we have some additional help. That additional help is you. You should know that the Michigan Department of Health and Human Services have provided grant funds for our court to use for our attorneys to have them do certain functions, which will include assisting parents in domestic relations proceedings as it relates to their open juvenile case. And that's why we're here today. This is your opportunity, our opportunity, to assist these parents in these domestic relations matter, primarily dealing with custody, but also some other things. It's also an opportunity for you to earn more attorney's fees because these grant funds are dedicated for that purpose. Our order of a program today is, I will be turning this over in just a moment to our presiding judge of the juvenile section, Judge Ed Joseph. He'll provide a welcome and introduction of our guest lecturer, the presiding judge of the Domestic Relations Division, and that's Judge Kathleen McCarthy. You should have access to the materials that have been provided to you on the court website that was sent out a couple of times in the last few days. You will have in that not only the PowerPoint, but the packet of information that you will be following along with. You should know that on your screen, you have a question and answer function. That is the way in which you can ask questions throughout this webinar, and we'll do our best to organize them and get them answered by Judge McCarthy. Lastly, in order for you to be certified, to be eligible to receive these additional attorney's fees that we have available for you to represent parents in these proceedings, there will be a 10-question true or false quiz sent to you immediately after this webinar. You will need to get at least 80% correct, 8 out of 10. They're not very difficult. It's not like a bar review or anything like that, but or bar questions. But we do need to certify to our grantor that our attorneys have received training and they have a base level of understanding of their representation of our parents in these matters. This webinar is being recorded. It's going to be on the court web. We're going to have it there for approximately the next 3 weeks. So if you have colleagues who couldn't make it today for whatever reason, we'll certainly let them know, but they're able to view what we have, what we're presenting here today. And they too will have to take the same 10-question test, true and false test. With that being said, it's my pleasure to introduce to you the presiding judge of the juvenile section of Third Circuit Court, who provide a welcome and introduce our guest lecturer. And I'm turning it over now to presiding judge Edward Joseph.
Thank you, Richard, and welcome everyone. Good afternoon. Thank you for your interest in the training and also for your interest in providing these enhanced services for the families that are on our juvenile court docket. We're very excited for the CPLR grant to begin. It's really a new journey for us in juvenile court. For many years, as many of you know, as practitioners in the court, these are services that we will now provide that have always constituted a roadblock on many of our cases to reunification. And so we're excited for the fact that for the first time we can offer these services and really move along all of our juvenile cases in a more rapid pace so that families can be reunited and we can essentially reach the goals that we're here for. As you know, in recent years, change of custody, paternity issues, guardianship issues, along with other issues such as housing and misdemeanor, criminal warrants have all been issues in returning children to the parents. Today, we're going to address a large portion of those barriers on the domestic relations side with this training. And so we're very happy to have Judge McCarthy here with us. She's got a wealth of experience and knowledge in the area of family law as the presiding judge of the juvenile of the domestic relations section, which is juvenile and domestic relations. They're all part of the family division. But as presiding judge, she brings a wealth of experience. She was elected to the bench in 2000, so she has over 20 years of judicial experience. Prior to that, she practiced in the area of family law before being elected to the bench. She's served as an adjunct professor at UD Mercy Law School, teaching family law. She's the past president of the Wayne County Family Law Bar Association. And she also serves on various boards, including the Mediation Tribunal Association, the Southeast Michigan Furniture Bank, and the Arab American Civil Rights League. So please extend a warm welcome to presiding judge of the Domestic Relations Division, Judge Kathleen McCarthy.
Thank you, Ed, and thank you, Richard, for asking me to be a part of this important training. You know, it's been an obstacle between the domestic side and the juvenile side in our court for 2 decades that I've been on the court, ensuring that we have one judge assigned to a case when we had one family. That's the intent of the legislature, and this is a huge step forward. We started the process a couple of years ago of transferring cases, and this is an opportunity, once they're over in juvenile, for the attorneys that are getting this training to really understand their role now that they're handling domestic cases. It obviously is different statutes and different laws apply. And it's an opportunity, of course, for the juvenile court to resolve a case by granting custody to the non-offending party. So everyone should have the information that I've presented. It's very well broken down, and I did that not only to bore you to death, but so that you had really thorough knowledge that you could take back with you if these issues come up in the future in juvenile court. So I have like a 68-page presentation. So bear with me. It's a lot of material to really get through in a short amount of time. And also in the materials is hopefully all of the documentation that you need to do everything that we're asking you to do in juvenile court. That includes complaints for custody, complaint for paternity, the motions that you would need to file, the orders that should get entered at the end, and some just practical information for you. So I hope when you're all done with this, you don't quit your juvenile work and go into custody cases. You can do that as well. You'll be all set for that. So I'm going to get started by starting the screen share. Okay, and all of this information, again, I know was on the juvenile website, and I'm hoping that you all have it with you while we're doing this presentation, or otherwise it won't make quite as much sense. So, and then as Richard said, if you have any questions while this presentation is going on, if you just write them in the question and answer, and then when we take a break, we will address them. There's a lot of material to cover, so I'm going to plow through the entire custody portion, and then we will take about a 15-minute break when we're done with the custody portion of the presentation before we start the paternity portion. So Richard addressed it. Why are we here? As many of you know, In re Sanders came down in 2014. And it clarified that while one parent might be the subject of a juvenile court proceeding, that doesn't make both parents the subject of juvenile court proceedings. And so then the juvenile judge should have the authority to place a child with a non-offending parent, usually the father, and then entertain any custody or motions that have been filed or complaints for custody that have been filed, and then switch their hat to go over to the domestic side and then use a Child Custody Act to change custody if an underlying order is present, or to initiate custody under a complaint. In addition, there was additional cases that came down that said if a family is subject to the purview of the juvenile court and a motion does get filed to modify custody, as you all know, oftentimes a non-offending parent will want to, or both parents usually will want to get out of the quasi-criminal proceedings in juvenile, and often they will, agree to change custody or allow the custody to be placed with the other side, or the juvenile court might do it. If any of those motions are filed while there's an open juvenile case, then the juvenile court must resolve those. I'm sorry, I'm just looking at notes as they're being presented to me. Juvenile court must resolve all the pending actions before it can terminate its jurisdiction. So we wanted to make sure you were fully aware of how to do that under the Child Custody Act and what the Child Custody Act looks like, because it's completely different than anything you're doing in juvenile. So there's a grant that's been given to the juvenile court, and the judges in the juvenile court will be appointing attorneys with an order that the juvenile court is putting together under basically 3 scenarios that the attorneys will be appointed. One of which will be to ensure that an affidavit of parentage has been properly filed with the state. I'm gonna go into that in a little bit more detail in the next slide. Number 2, to file a complaint to establish paternity in the right scenario. And number 3, file a custody complaint or motion to change custody when a child is going to be placed, I say with dad, but primarily the non-offending parent in the juvenile court. I don't know if you're aware, but our court handles about 400 cases a week started by the state of Michigan when children are being supported by state aid. And an affidavit of parentage is used in those cases. If a dad wants to sign and acknowledge that he's the father, those affidavits of parentage indicate on them that the mother is provided custody unless or until another custody order is put into place. So there's a lot of our cases that just an AOP has been signed. Some of the cases a birth certificate is in place. And then some of the cases, none of those are in place, and we need to, if we're gonna, juvenile court's gonna release the child to the non-offending parent and no underlying affidavits in place, birth certificate, or a prior court order, then something has to be established to give them that legal authority to keep the child there in that placement. Okay, so there's 3 possible scenarios where you're likely to get appointed to handle these juvenile cases. The first one is what I was discussing with regards to no legal father existing. And genetic testing is done over in juvenile that shows that the father is the biological father. There is no underlying custody order in place from our court. Then an attorney, and likely in these situations, the juvenile court is not changing custody, likely to give custody back to mom when the juvenile proceeding is done. But dad wants to make sure that his rights are preserved so that in the future he could file an action in the domestic court. So under that first scenario, custody is not being changed, usually from mom. And that's a situation where the attorney is going to be appointed. The application or the AOP is in your documents that we've attached. It's very important that not only does the AOP get executed by both parties in front of a notary, but it has to be filed with the state. And often that's the part that doesn't happen, and the state has no record of a legal father. So the attorney is going to be appointed to ensure that that AOP is properly filed with the state. And then you're going to seek reimbursement out of the grant money for any fees that resulted. Number two possible scenario is that a legal father exists because there's an AOP on file, an affidavit of parentage, but there is no prior custody order in the domestic, on the domestic side of the court. In that case, an attorney is going to be appointed to file a complaint for custody and to ensure that that complaint gets transferred over to the juvenile court. So that the juvenile court can adjudicate custody through the Child Custody Act. And the third scenario is there's a current custody order that exists in the domestic side. Usually mom is going to be the custodial parent. She is subject to a juvenile court proceeding, and likely her custody is going to be changed based on the severity of the juvenile referral. And in those cases, the attorney is going to be appointed to file a motion to modify custody. Okay. And under either 2 or 3 is the resulting pages of this training is going to show you how to present your case to the juvenile court. There's going to be a fourth scenario that does occur over in juvenile court, and that is when you have a legal father that has signed an AOP, mom is subject to the jurisdiction of juvenile court, or the legal father is subject to the jurisdiction of the juvenile court, but a third party comes in and says, hey, wait, or mom says, or dad says, I'm not really the legal father. And that new third party father is going to want to revoke the AOP that the legal father has on file, or the legal father is going to want to revoke the AOP, or the mother's going to want to revoke the AOP. Because there's already an existing legal father in place for the juvenile court to act, they are not appointing attorneys for those scenarios. I'm going to give you just enough information to know that those motion packets are online, and the alleged bio-father can file a motion that's directed to me as the presiding judge, and but that's not something that you guys will be appointed to do. But because it exists, I wanted you to make sure that you're aware of it. So types of custody. In the domestic side, under the Child Custody Act, the statute, which we've provided in this documentation at 722.26a, does not break down custody definitions. It doesn't specifically say physical custody or legal custody, but the practitioners going back long before I took the bench have always broken it down in that way, because it helps simplify matters for the parents themselves to know who has physical custody, who will the child primarily reside with, which is a definition of physical custody, and who has legal custody, which is important decisions regarding the child, education, medical, or religious decisions. For clarity of judgments, we do break those two apart because they have legal ramifications. Often school of choice becomes an issue. That falls under legal custody. If both parents have legal custody, then even the custodial parent can't unilaterally decide where that child's going to go to school. It does help, though, with providing that documentation to the schools, therapists, etc., to break down who does the child primarily live with. It also helps if somebody's claiming the child as an exemption on taxes. And it also helps in post-judgment to have a good understanding of with whom the child primarily reside, who had legal custody, and what the parenting time situation is. So we do ask for clarity in your judgments that you're ultimately going to be presenting to the juvenile court, that you separate those two and you have as much detail as possible in those documents. Okay, custody and parenting time determinations is always resolved in the best interest is always resolved as to the best interest of a child. It's always looked at from a child's standpoint, not necessarily the parent's standpoint. In order to change custody, and whenever you're preparing a case for custody, everything must start with a few simple questions. One is, is there an existing custody order? If so, a movement, and if there's a juvenile case presented, usually that is sufficient for proper cause or change in circumstance. But a movement must show that there is proper cause or a change in circumstance that warrants a modification of an existing custody order. The burden of proof for the movement depends on whom the child has an established custodial environment. So you need to know this area of the law to present your issues to the juvenile court. So first, you must always show with an existing custody order, proper cause or a change in circumstance. What does proper cause mean? It means that proper cause, you must show that there's a significant effect of the child's well-being and at least one of the 12 best interest factors. We're going to get into the 12 best interest factors in detail, but whatever has occurred in the household must be significant such that it affects the one of the 12 best interest factors. Some of this is going to be common sense, some of it not so much. Often in domestic side, we get motions filed for little things like maybe somebody hasn't allowed somebody else parenting time. Unless that's a routine and common situation that's occurring, you resolve that by an order to show cause. You don't get to change custody. And again, some of your litigants might be subject to juvenile court because they left a child home alone and the cops got called and there was a concern. And some of them are going to be significant, like if there's beating of the children taking place, you've got a chronic drug or alcohol problem. Clearly, that would be significant enough for the juvenile court to review proper cause or a change in circumstance. So it's a case-by-case situation. And again, you must argue it has a significant effect on the child's well-being. A change of circumstance. Again, it's just a reiteration that the movement must show that the conditions surrounding the custody of the child have materially changed. It is kind of a high threshold. And again, it must have a significant effect on the child's well-being. There is a case here in Ray AP that the court found that the fact that the family was subject to juvenile court proceedings in and of itself was significant enough to have proper cause or a change in circumstance. You have to understand, though, that if a motion gets filed in our court, transferred over to juvenile court, the judge is going to be reviewing this at the end of the juvenile court proceeding. So they're not going to entertain any of these issues until they have resolved the juvenile part of their case. And then they'll take a look and see whether any of these motions or these cases have been transferred over from a complaint. If it's a motion and the issue is resolved, let's say it's mom left the kids home alone and somehow the police got called and DHS thought it was significant enough to start a case. If that issue has been resolved to the juvenile court's judge's satisfaction, that mom now has babysitters in place, mom now has gone through the appropriate parenting training or whatever the juvenile judge has decided, that motion might be in front of the judge and the judge can review that motion and just simply indicate that there is not a proper cause or a change in circumstance sufficient to reopen the custody, meaning that the judge intends to return the child to mom. They would hold a motion hearing. They would have to make findings that based on the allegations presented in the motion, they don't rise to a material change in circumstance. And if that's the case, they never have to review the child custody factors. They can, like almost a motion for summary disposition, they can state what the findings were, that this didn't rise to a material change, and dismiss the motion or deny the motion for not having merit without having to conduct a custody evaluation. So again, when you're filing these motions, make sure that you have clarity and specificity as to how it has materially and substantially changed the child's well-being. Okay, and to know what burden of proof that you're going to apply to all of these cases, you have to start at the beginning. And the beginning of every child custody scenario is whether there's a proper cause or change in circumstance, if there's an existing case, and if there's a non-existing case, what is the established custodial environment? Determining what the established custodial environment is, or the ECE, tells you what your burden of proof is before the juvenile judge. And it's very important to always start with your analysis there. So in a lot of our cases that we process, the 400 a week, these are moms that are have primary physical custody. The dads are either non-existent or they aren't helping substantially with their children. So in a lot of our state-initiated cases, mom has sole physical and sometimes sole legal custody, and there's maybe limited parenting time or no parenting time. Ordinarily, just looking at the last custody order in place, which is always important to know what that order is, we can often assume that mom has the established custodial environment. Okay? A custodial environment is established if over an appreciable time, and that word, and we'll go through this and break out these words because they're significant to the statute. If over an appreciable time, the child naturally looks to the custodian in that environment for guidance, discipline, necessities of life, and parental comfort. The age of the child has to be taken into consideration, the physical environment, and the inclination of the custodian and the child as to the permanency of the relationship to be considered. What does all that mean? And we're going to break this down a little bit, but you have to understand that custody orders in and of themselves do not make an established custodial environment. At its simplest form, an established custodial environment is always looked at from the child's standpoint, and it's how the child feels about one or both of their parents, okay? Don't get confused that just because a custody order in place, mom has the ECE. Don't be confused that if this family is subject to juvenile court, maybe it's a simple situation. I'm not in that, I know most of the stuff that you guys see is terrible and obvious that there's a big problem, but it could be like, you know, mom not being home because she was working and leaving the kids home alone that came to the attention. If she has then put things in place and a juvenile case starts in March and by July or August, the situation has been resolved in the judge's mind, that's not a significant period of time from a child's standpoint if you have an older child. But if you have a younger child that's maybe 1 to 4 or 5 years of age, not seeing a primary parent for 6 months absolutely can change the established custodial environment. So it often depends on the age of the child, how long the situation's been occurring, and what has been the contact with both parents. You can have an ECE with only one parent, with both parents, or neither parent. If you have a juvenile case where both of the parents were abusing and neglecting these children, from the child's standpoint, they're not looking to either one of those parents for parental comfort and guidance, and the established custodial environment has broken down. Okay, and you need to know that because when you address your burden of proof, it becomes very relevant. If a child has an ECE with a custodial parent, in this case normally mom, and is subject to a juvenile court proceeding, then dad is going to be filing a motion to change custody or start a new case to acquire custody. In which case, if mom already has the established custodial environment, then the burden of proof on the motion is by clear and convincing evidence that the change in custody is in the child's best interest. In a second case scenario where I indicated maybe that both parents were subjecting the child to abuse and neglect, so there is no established custodial environment, that child is not looking to either parent for their care and their comfort. They might be with grandma, they might be with Child Protective Services in a foster home. There is no ECE. And so therefore, when you're addressing the child custody factors, the burden of proof by the petitioning party is only a preponderance of the evidence. So we have clear and convincing evidence standard or a preponderance of the evidence standard when you're analyzing the child custody factors. And that's why you always have to start with this ECE in your analysis of that. People throw around these terms, but I wanted you to have a clear understanding of what clear and convincing evidence means. The evidence produces in the mind of the trier of fact, which is the judge, a firm belief or conviction as to the truth of the allegations sought to be established. The evidence is so clear, so direct, so substantial and convincing that the finder of fact without hesitancy knows that at the end of this child custody analysis, I'm going to place this child with X. That's clear and convincing evidence. That's something that even our trial judges here on the domestic side have to be reminded of. That when we're questioning, hey, what would you do in this scenario? Hey, what would you do in this scenario? I always say, what's the burden of proof? And if the burden of proof is clear and convincing and you're asking somebody at the end of that presentation what they think you should do, then that's not clear and convincing evidence. That burden has not been met. And it's important for you as attorneys to present that analysis to the juvenile judges. And you have to start off with any custody presentation or trial with what is the established custodial environment and what is the burden of proof. If not, it is reversible error by the Court of Appeals. So you want the ECE, who is it with, and what is your burden of proof? Is it clear and convincing, or is it preponderance? Preponderance is just a little bit more than 50-50. It's not, clear and convincing, I say, is like climbing a mountain. Preponderance is just a little bit more. The evidence presented must persuade the finder of fact that it's more likely than not that the disputed fact is true. That at the end of the child custody factors, it's a little bit more, I feel more comfortable giving this child primarily to mom or primarily to dad. Big difference between the burdens of proof. So it's very important that you analyze that from the get-go, because then you can advise your clients whether it's even likely they're going to prevail or not. If it's clear and convincing evidence and it's an issue that's been resolved by mom in the juvenile court, then they might not even want to file the motion. It might be a waste of time because the judge may just deny the motion as not having met the appropriate burden. Okay. So analyzing the established custodial environment from the child's eyes naturally looks to the custodian means when I'm hurting as a young kid or I need seeking comfort, I choose one parent over another. In that environment means the entire surroundings of the child, the family unit, the dwelling, the geographic setting, the neighborhood. In which environment does that child feel call home? Which environment do they feel that they are more settled, more comfortable? The guidance, which parent are they looking to assist them if there's problems in their life or something happened at school, something happened, obviously one of the parents is subject to a juvenile court proceeding. Are they running to the other parent, or do they hardly know the other parent and are looking to grandma or to an aunt for comfort over one of the parents? Discipline, again, this is the whole definition of the established custodial environment that I'm breaking down in detail. When you're looking at, from the child's perspective, is one parent able to discipline the child in an appropriate way, or are they using inappropriate parenting styles? This just breaks down different parenting styles, and one isn't necessarily bad or better or worse, but it can affect whether there's an ECE. This is whether a parent provides for the necessities of life. That includes food, clothing, shelter, medical care, education. Parental comfort includes love, affection, consoling, and reassurance. You might have a parent that's not big on disciplining, has very permissive parenting, but they're the parent that goes to work every day and puts food on the table and showers his child with love and affection. So you have to look at the entire definition. The age of the child as to the established custodial environment is very important. The younger the child, the shorter period of time is needed to establish a custodial environment. Obviously, a child's brain capacity at 2 is very different than it is at 12. So if you have a mother away from a child for a period of 6 months or more, it absolutely can change the established custodial environment. So you might have had a child that lived primarily with mom, but then subject to the juvenile court proceedings that maybe went on for a lengthy period of time, over 6 months. Even though mom had primary custody before juvenile court, and dad may have been little to non-existent, but through the juvenile court proceedings, he established regular parenting time, and then placement perhaps happened with dad. That could completely change the established custodial environment. So those are the facts that you need to supply to the juvenile judge as to why the ECE is with one parent or another. And you have to really, and the juvenile judges have to state with specificity why they think the ECE is with one parent or another. Physical environment includes the surroundings, the family, again, the neighborhood, accessible services. You might have a child with special needs, and in one home, the child has access to special needs, the parent is taking them, the parent is helping with schoolwork, etc. Inclination of the custodian and the child as to the permanency, in which home is there security, stability, and there's a long-lasting relationship. Again, all of this has to be analyzed through the lens of the child, not the parent. And again, custody orders in and of themselves do not create an ECE. Okay, I'm just providing you, I won't kill you with going through all these statutes, but the statute for custody in the Child Custody Act is MCL 722.23. And it's always important to refresh your learning and going back to the statutes as the basis of law. Obviously, as an attorney, you're applying the facts to the law. And so you should be familiar with what these statutes that I'm providing for in your materials. You should take a look at them and spend a little time with them so that you're prepared to address these factors. 722.24. I'm providing this just to let you know that obviously the court has to look at the inherent rights of the child and establish their best interest. It comes from this statute. And the court has to set parenting time in accordance with the statute as well. And this also statute indicates that when a lawyer guardian ad litem or other assistance can be appointed through the Child Custody Act in resolving this child custody dispute. At times, a guardian ad litem, you have guardian ad litems in your juvenile portion of the case, but you can also, here's the authority to appoint them in the child custody portion of your case. You can have those same resources appointed. MCL 722.25 just tells you that if a child custody dispute is between parents, between agencies, or between third parties, again, the best interest always controls, but if it's between a parent and a third party, grandmother, foster care agency, and you're applying the Child Custody Act, your burden of proof has to be established by clear and convincing evidence. So there's a lot of law in Michigan that absent a significantly neglectful or abusive or termination of parental rights, that custody, the parents have a constitutional right to have custody of their children and to decide routine matters involving their children. And we cannot, as courts, deny that right. And if we have a third party competing for that custody, a grandparent, etc., again, it goes back to your burden of proof. Under the child custody factors, can the grandparent show by clear and convincing evidence that it's best interest for this child to remain living with them? Okay. Joint custody, again, I'm just making sure that you understand where these definitions are coming from and how the law applies to them. This is 722.26a. It describes what joint custody means. Remember, I said at the beginning, you don't necessarily need to break down physical and legal custody. This is a statute that says that. But this statute also says that if the court awards joint custody under paren 3, the court may include in its award a statement regarding when the child will reside with each parent, and may provide the physical custody be shared by the parents in a manner to assure the child's continuing contact with both parents. Just like the juvenile court, you always want reunification and a strong relationship with the biological parents if possible. In the Child Custody Act, this is the same situation. And if you're not doing that for one of the biological parents, you have to make specific findings as to why that's not occurring. I also want you to know, and I'm not going to go into depth about this, but there's a separate parenting time statute as opposed to the child custody factors. So here in our court, often after we get through a child custody analysis, then we have to address the parenting time factors. I want you to be aware that they exist, that you should look at this statute. Because absent the parental rights of one of the parents through the juvenile court, it is presumed or to be presumed that the child should have a strong relationship with both parents. So let's say you have a case where the child had primarily lived with mom, and mom's rights are affected through a juvenile proceeding. Maybe she has a drug or alcohol issue. Maybe she's with a new boyfriend that's hitting the children and she won't leave. Maybe there's domestic violence in her home with the new spouse and she won't leave. We can place custody with dad. We can award him physical and legal custody, but we still need to set out parameters for parenting time for mom that will somehow get her back to a good relationship with the father. So we have to be careful in juvenile court to, we shouldn't be entering orders that reserve parenting time absent making a finding by clear and convincing evidence that parenting time would be create emotional and physical harm to the child. And we perhaps want to put parameters in there, like maybe mom has to have a year of AA with no violations of parenting, of drinking or drugs, having, she has to undergo 6 months of drug testing, random drug testing, before she can file a motion to modify parenting time. So you can reserve parenting time under only the most extreme situations, frankly, and you have to make findings about why you're doing that. And then absent a termination of a parent's rights, you have to create a formula that the parent can regain some more significant parenting time. So if it's supervised because of something going on in a house, there has to be an order in place that says you can get off supervised parenting time if you do X, Y, and Z. And that's when the court sets up review hearings. In the juvenile court, it's the domestic side that would handle the juvenile, review hearings. As long as a clear order is in place, that order at the end, final order would get entered. It might have parameters in place, and then it would get transferred back to the domestic division, and we would have the review hearings to make sure that these things are being followed through with, or we can continue somebody on supervised parenting time. Parenting time, again, a separate statute, 722.27. And again, we have to provide for parenting time for a party unless it's determined that it's harmful to their physical or mental health. This statute lays out what the factors are when you're looking at parenting time, what you should consider. The existence of special circumstances or needs of the child. If you have a special needs child that has medical issues, perhaps mom doesn't have a vehicle, won't be able to take the child to get the medical care she needs. That might be a reason that you're providing custody to dad, but you still have to provide parenting time. Does the special needs interfere with mom having a Sunday of parenting time or a weekend of parenting time going forward? Those are the things that you need to look at. The likelihood of abuse or neglect during a child during parenting time. The abuse of another parent resulting in parenting time. If you have a violent parent that has domestic violence perpetrated on the opposing party, and being in any proximity with them can result in further domestic violence. Those are situations where you would consider in the parenting time, putting safety guards in place. That's what the second part of the statute says. The parenting time order should account for whether third parties should be present, whether certain times should take place for parenting time. Specific times are always better, because otherwise, orders that say reasonable and liberal parenting time should never be entered. That just requires the parties to come back on the back end and file a motion to modify custody. So it's just doing double work. Just set the provisions in place and then let the party file a motion to modify, indicating that they want more parenting time after the resolution of whatever brought them to the attention of the juvenile court. Okay, so I wanted you to be aware that those statutes exist, and you should be looking at them, and they're a separate statute for custody and a separate statute for parenting time. Looking at the best interest factors, from the juvenile perspective and domestic perspective, the court must consider each factor, and you're required to make specific findings on the record regarding each factor. Keep in mind when you're addressing the child custody factors, what the burden of proof is. That should have been placed on the record, or that finding of what the established custodial environment needs to be stated on the record, and what the burden of proof is, or otherwise it is reversible error. So it's important for the lawyers that when they're representing in a new case or a motion to modify, that they know what the ECE is, that they argue it to the judge, and then indicate that what their burden of proof is in this case. And when you know what your burden of proof is, and you know it's clear and convincing, you know that you need to go through each one of these factors and present all the information that you possibly can, so that your client prevails in that action. Okay, so we're going to go through the child custody factors. Factor A is the love, affection, and other emotional ties existing between the parties involved in the child. This factor focuses on the current bond between the child and the parent. It favors the parent who is emotionally closer to their children, and it disfavors people that don't have appropriate boundaries with their children. That would be an example of, mom and daughter are best friends instead of a mother-daughter relationship, and mom is taking the daughter out to house parties with grown people. That would be an example of the mom might love this child greatly, but she doesn't understand appropriate boundaries and putting this child in physical and emotional danger. The court should assess the emotional ties between the parent and the child, the amount of affection shown, how is it shown, quantity and quality of time spent. You might have, a working father who works long hours and is supporting the children. Clearly, that's an indication of love and commitment to the family. And if you're representing the dad, you want to point that out. But on his free time, is he then going on the couch and falling asleep with a beer in his hand, or going in his room and watching TV the rest of the night? Or is he spending some time with his children and going to the park to play ball? Is he, involved in their education? Is he involved in their friendships? Is that all appropriate? Okay, things you continue to look at is, who does a child seek out when distressed or happy? If they have a great grade in school, who do they call? Their mom or their dad? Who do they confide in about problems at school, bullies at school, maybe whatever's brought them to the juvenile court? And then again, are each of these parents establishing appropriate boundaries? Are they getting these children involved in the court proceedings? That's always a big one to look for. Are they coaching them to say one thing or another? Those are things you look under love and affection, factor A. Here's just a case, Shakur versus Shakur. It favored the father when the court found that mother terrorized the children by spanking them with a belt. Something like physical discipline, and I've certainly seen that in my 20 years of practice, can almost overnight change the established custodial environment with the child. That they may be very closely bonded with a parent, but if they get a beating or a spanking, that they no longer feel safe with that parent at all, and it can completely change the whole dynamic of a relationship. And that's what you would be arguing to the juvenile court. Maybe it was only one incidence of a belt being used, but sometimes one incident of a belt or a significant beating is all that it takes for any trust and security for that child to feel towards a parent. Okay, factor B, the capacity to give love. In this case, we look at the current bond between the child. Factor A focuses on the current bond. Factor B kind of focuses on the future bond. What does this parent bring to the table to provide this child with guidance, education, raising the child in any religion or creed? You know, is one parent following up with religious decisions, taking a child to church, another parent's not? Those are things that we look at in factor B. You should know that there's a difference between, we say capacity and disposition as if they're the same thing. Parents could have the capacity, a mom could have the capacity to give love and to show love, but she doesn't. Maybe she withholds that. Maybe she's turns to alcohol or drugs instead of spending time with her children, taking care of them. You can have the ability, but not the willingness. And capacity and disposition are two different things. One is the ability and one is the willingness. And you need to be able to break those down to a judge. You might have a mom that has had the custodial environment, but she's been messing that up in a big way, which whatever was brought her to the attention of juvenile court. So again, she has the intrinsic ability to provide for her child, but she doesn't have the willingness to do so. An example is factor B favored a mother because she displayed a greater capacity than the father to give love. She was a parent who signed the minor child up for activities, arranged play dates, set boundaries for child's behavior, was a child's disciplinarian, and was consistently present in the child's life. You might have an example where, parenting time with dad is sitting in front of a TV and playing video games, and dad's not making sure the child is fed, making sure the child's doing their homework on their time. They might be the fun dad or the fun parent, but they're not making sure the child has whatever they need to be successful in life. That's kind of what factor B is looking at. Factor C is a child's physical needs, the capacity and disposition of the parties to provide the child with food, clothing, medical care, or other remedial care. This is where you start looking at the ability of parents to provide for their children. You want to look at employment, what their hours of employment are. When they're not working, are they spending quality time with their children? Or like I said, are they going to lay on the couch or hide in their room and let the other parent take over? Having a job in and of, having money in and of itself or significant money in and of itself can be equalized by child support. So you don't want to focus too heavily on that. But if one parent hasn't been working for a significant period of time under the child custody factors, they don't have stable income, they don't have steady income, those are things that we look at under factor C when we consider them. Does one parent's job have health insurance that is a benefit for a child? Do they have money put away in retirement? That all goes to having a child know that they're at the end of the week, if they don't get paid, that they're out on the street. Frequent changes of houses is significant here. The ability to provide food and put basic food and clothing on the table. Making sure there's beds in the house with mattresses or a kid sleeping on an air mattress. These are the things that you look at for factor C. Again, this is factor C, looking at past and future behavior, ability and willingness, financial means, who plays a caretaker role. In some of our cases, in your cases, I know that the fathers haven't had any contact with these children in any significant way, and then they file a motion to modify custody. So if they can't show these things, those are conversations to have. Obviously, if the mom can't regain custody, then you're looking at the other natural parent to provide custody. These are things in preparation for a custody trial that you want to go over the best interest factors with your clients and make sure that you have information to apply to each of these factors that's going to favor your client. one of the other things is any special needs of the child. That's very significant. And you could have two children in the same home that have different ECEs with their parents, and you could have two different children in the home that have separate needs. And when you apply the child custody factors, it might be appropriate. We don't tend to want to split children, et cetera, but sometimes these factors have to be addressed in a different way, depending on, with a different burden of proof for the different children in the home. You might have an older child that the dad has had little to no contact with, and the ECE and the burden of proof might be clear and convincing for that child, but the younger child he's had more contact with, and his burden of proof with frequent parenting time might be preponderance of the evidence. So you should be aware of that, and if the situation occurs, then you need to make those proofs appropriate for the juvenile court judge and say, you know, for child A, the burden of proof is X, for child B, this burden of proof is Y. Again, physical needs, we're looking at stable housing, beds with mattresses, working utilities, stove, refrigerator. That's providing the security and comfort for the child. How do you assess that? You look at the history given by parents. Maybe they're keeping a calendar of how often dad has come to see the kids. You can get medical records to show who is a primary parent that takes the child to the doctor. Who's a primary parent that is taking the child to school, signing in on at daycare, signing in or picking up from school, attending parent-teacher conferences. All of those things are things that you address in physical needs. Factor D, the length of time the child has lived in a stable, satisfactory environment and the desirability of maintaining continuity. This is, again, looking at the child's physical setting. Does the parent with whom the child primarily lived provide a safe and stable environment? Are they frequently moving? Are they being evicted? Are they changing schools frequently? They have furniture in their house? Do they have a mattress? Some of these custody factors overlap, but you can look to all of them and find, address them appropriately with the court. A stable environment, again, looks at how many times you've moved. Are there danger in the home? Is one parent, is there domestic violence in the home? Is there drugs, alcohol? All of those things go to the stability of a home. A parent, in your case, mom might have had a home for, you know, multiple years with the child, but within that home, she has a new partner that's committing domestic violence that the child is witnessing. She may be involved with drugs or alcohol. So they maybe have a home, but it's not really a home from the child's point of view. They're afraid, they're subjected to mental anguish with this domestic violence, physical danger. Those are the things you look at. In this case, as to factor D, it favored the father when the mother coached the children to make allegations of sexual abuse against the father. Coaching of the children interrupted the ECE of the child and certainly jeopardizes the child's mental and emotional state, not including subjecting them to physical exams. So those are all things that you look at. The permanence is factor E as a family unit of the existing or proposed custodial home or homes. It focuses on the child's prospects for a stable family environment in the future. Factor E is you're looking in the future. You're finishing up a juvenile case. There may have some significant drug or alcohol issues going forward. Maybe mom has gone through AA. She hasn't touched drugs or alcohol in a year. There's positive drug screens. So there's no reason why a new home with dad is going to prevail under factor E in that type of scenario. You might also consider, is there close family members? Is there a grandmother that's significant in the child's rearing? Is there a brother? Is there a sister that the child is close to? Somebody that provides regular daycare and support? Those are the things that you look in factor E. Factor F, moral fitness. It's one of the most contentious and improperly analyzed factors because if we look at anyone's morality on any particular day or time, you know, we're going to find a fault with everyone. What we need under moral fitness is the moral fitness as a parent. So if I'm in an environment, child's in an environment with mom, and she has a boyfriend that comes over on the weekends when the child is at dad's, and they're partying, they're doing drugs, they're doing alcohol, there's domestic violence. If the child's not witnessing any of that, not involved with any of that, then that really doesn't go to factor F. It has to show a significant effect on the child. Cheating on one's spouse, we consider that when we look at moral fitness. How did that impact the child? Those are if it doesn't, if the child is completely unaware of somebody's philandering, then it's not an impact for moral fitness. Marijuana use, drug use, if somebody renders a parent incapacitated or unstable, you know, everyone is smoking marijuana now. But when we look at this factor, you know, I just had a case this week where the child at 3 was tested positive for marijuana. That's because she was in significant close proximity to mom while she was engaging in smoking bongs on a regular basis, such that the child was testing positive from secondhand smoke. That would be something significant under moral fitness. Or it could be, in my case, mom was giving the child Benadryl to have the child sleep while she was online engaging in sex acts with her boyfriend. That's a moral fitness issue in and of itself, because she was giving this child Benadryl so that she could free herself up to do these behaviors. Her doing that on the weekends when dad's not involved may or may not be something significant on moral fitness. You look at on moral fitness, you know, prison sentences, what was it for, what was involved with that. Those are all things that you can look at under moral fitness. Factor G, a parent's mental and physical health. Again, the disability must affect the parent's ability to parent. I had a case where the man was confined to a wheelchair, and then I had a young child involved, and dad wanted significant parenting time. The reality was his physical mobility limited his ability to care for a young child who would be running in and around the house, that you can't stop them from getting into something dangerous if you wanted to, if they didn't have mobility of their hands, their legs. These are things that the mental health may affect. You know, in and of itself, somebody taking depression medication or using marijuana that doesn't involve them not caring for their children might have no significant effect on a parent's mental or physical health. Significant obesity, where a parent can't move to the extent that they're not caring for their children, or they're sitting on the couch all day. Those are things that you would address under Factor G. Past suicide attempts might show a history of continued mental health issues. Domestic violence in a new relationship in your home very much would affect placing a child, or the ability to place a child in harm's way if it escalates. In this case, despite father's alcohol consumption while taking antidepressants, there was no evidence that father's alcohol consumption and depression affected his ability to parent. So again, if these are things that are happening outside of the purview of the child and they're not directly affecting the home, then they might not be significant as to Factor G. Factor H, the child's homeschool and community environment. This is always a significant factor for domestic judges, depending on the age of the child. If you have a child under the age of, 6 or 7, this factor might not be very relevant at all. The younger the child, they don't have a significant footprint in their community, likely. They may be being cared at home or cared at relatives' homes or in daycare. They're not necessarily involved in significant extracurricular activities, but the older a child gets and the more that their footprint in the community is established, changing or disrupting that can be very significant. If you have a teenage child, you know, all of us know that they really don't want to be with either parent. They want to be with their friends. They want to be out in the neighborhood. They want to be in their stable school. So those are things, again, from the child's standpoint, you know, mom might not be the best mom in the world, but dad lives in a whole nother community or a whole nother state. And this child is stable in their home environment, their community environment, with regards to extracurricular activities, with regards to getting good grades in school and having a good support network of friends in the community. The older a child gets, the more significant factor H can be, and disrupting that would be significant. The child's preference. So this is reversible error if a judge does not get a child's preference. Court cases have indicated that a child over the age of 6 is old enough to express a preference. This is done in chambers or in our virtual world in a breakout room with a child, usually placing a child in a separate room, making sure that the parents pan around the room in the virtual world, that nobody else is in the room able to influence the child, making sure there's a closed door to talk to the child, asking the child to go outside with the phone so that no one is in close proximity. But taking the child's preference is mandatory, and a time does have to be set up to gather that preference. Case law indicates that the preference has to be a reasonable preference. So a judge is allowed to ask questions to establish a reasonable preference, but they shouldn't go on a fact-finding mission with the child. We shouldn't be using factor I to confirm that mom is having sex with her boyfriend in another room when the child's there, or that the mom is smoking pot, or that et cetera, et cetera. You don't go on a fact-finding mission, but you have to state a reasonable preference. You ask the child, you know, who takes them to school in the morning? Who cooks food for them? Who do they turn to if they're unhappy? I always ask my kids, you know, do you know why you're here today? Do you know what this involves? And some of them know it, and some of them don't know it, depending on whether parents talk to them about it or parents coach them. In the juvenile setting, if you've already referred the case to family evaluation and mediation, and perhaps there was extensive juvenile proceedings involving a child, and testimony has already been taken of a child, you can use that testimony for factor I without re-interviewing a child. But be very cautious about that. If that is done, you need to make a very clear record that the court relied on the FAME interview that talked independently to the child and sent the preference to the court, that there were extensive juvenile proceedings, and the child was put on a witness stand. The child met with a therapist, and the therapist has provided you information about the child's preference. But by and large, you do have to take the testimony of a child or state with specificity why you did not do that. Factor J, cooperative parents, the willingness and ability of the parties to facilitate and encourage a close and continuing parent-child relationship. This favors a parent when the other parent displays animosity towards him or her. We have these parents, of course, that, you know, something happens in juvenile court and the other parent jumps in and wants to, having little to no contact with the child for many years, now sees this as an opportunity to get rid of their child support arrearage. This is when, you know, one parent's been cheated on, and so they do nothing but defile the other parent to the child. They engage in active alienation of a child. Is one parent just so immature that they can't get over whatever the rift is between these parties that occurred, and everything is about that instead of trying to build a relationship to be able to communicate appropriately without offensive words, to inform the other parent of things that are happening in the child's life, whether there's any medical appointments or school appointments or, you know, school activities important for the other parent to engage in. You just do need to make sure that obviously when there is domestic violence involved in a home, that can affect every one of these child custody factors. And so if there is domestic violence between these two parties and mom is hostile or very guarded about allowing dad any custody or parenting time, she might have an appropriate basis for that belief. And if it's grounded in fact that something has occurred to make her feel that way, that needs to be acknowledged and recognized. And then what you want to do is, if parenting time is appropriate with the offender, obviously make sure that that's in a supervised setting that's appropriate to secure the well-being of the child. Again, domestic violence is one of the factors. Domestic violence needs to be, whether it's directed against the mom or witnessed by the child, it's significant to the child. If you have mutual domestic violence, which can occur in very volatile relationships, and that's something to consider for both parties. The other thing I want you all to make sure that if there's a history of personal protection orders, you should obtain those, the basis for the acquiring the personal protection order, the fact sheet that was submitted before trial. Make sure that you have the police reports, that you have subpoenaed them or got them under the Freedom of Information Act. You should secure the child's or mother's medical records if she's been beaten by dad, photographs of bruises, etc. That's the kind of evidence that the court needs to see when determining domestic violence. Obviously, not in every case you're going to have medical records or police reports. A lot of people don't call the police in these situations. To the extent that they're available, they're a very important tool to consider and make sure that you present for the judge. When I indicated to you about getting the basis for the PPO, look at the reasons why a PPO was granted. You especially want to consider anything that involves the lethality factors. The lethality factors are an indication of the more of these factors that are present, the likelihood that one party or the other is going to try to kill that party in a DV situation. And obviously, the more lethality factors that you have in a case, your alarm bell should be going off, and you want to be making sure that this child is either not having any parenting time, again, a reason to reserve parenting time, or you want to make sure that any parenting time is taken in a safe setting where a third party can remove the child if there's any danger mentally or emotionally or physically. So I wanted to provide these lethality factors. They're always significant. They're significant for personal protection orders. They're always significant in domestic violence cases, always significant in child custody cases. And whether there has been physical violence in the past, does a party own a gun? Is there unemployment present? Has somebody used a weapon or pulled out a weapon or threatened to use a weapon in the past? Have there been threats to kill? When you have children in a home that are not children between the parties, is a higher stress and a lethality factor. Obviously, forced sexual conduct is significant. One of the most significant lethality factors is a prior situation of choking, strangulation, or cutting off breathing. Very significant lethality factors. If someone is choked out, it is one of the leading causes of death in domestic violence cases, and it takes a very short period of time to cut off someone's breathing such that they have brain damage or die. So it's a very significant factor. Using illegal drugs, alcohol or drinking problems, controlling your spouse's daily activities, constantly jealous, throwing things around the room. When a woman's pregnant, there's some physical abuse of the woman, threats to harm children, leaving notes, following you, tracking your car, destroying your property, taking medication that you use is significant, or ever having threatened or tried to commit suicide themselves is all part of the lethality factors you want to take extra caution with, and make sure you present those to the juvenile court judge when they're considering the child custody factors. And the last child custody factor is factor I, which is a catch-all factor. Judges have tremendous discretion under factor I to consider anything else that didn't fit into one of the other factors that they think is relevant. It might be relevant that somebody hasn't had any contact with the child in 10 years. And now because a juvenile case started, they've come out of the woodwork and again, they want custody and they want to wipe out all their child support arrears. It could be any number of things. Nothing specifically comes to my mind. You know, a party not showing up for court hearings is something that I comment on factor I. And then any other evidence that you want to make sure is included in your opinion would go under factor I. Anything else the court should consider as an attorney should go under factor I. And within each of these factors, when the judge states their decision, they need to say factor A favors mom or favors dad, not just reciting the factor and what they considered, but also who prevailed on that factor. And so to the extent that you're in front of a judge that fails to do that, as an attorney, you want to make sure you make a proper record. And you would say, you know, judge, under factor A, did that favor my client or did that favor, and then have the judge elicit who was favored under those factors. It helps significantly with any appellate, with any appeals if they follow. Okay, so we're almost getting towards the end of our child custody presentation. And so this is going back to our first scenarios that we talked about where you're going to be appointed as a judge. I'm sorry, you're going to be appointed as an attorney to represent parties. So scenario one was when no legal father exists currently, genetic testing is done in juvenile court, and it indicates that the person is the biological father. The attorney is going to be appointed to make sure that that both parties sign the AOP, that it's signed in front of a witness, and that you send in the form to the state with the appropriate filing fee. Until the AOP is filed with the state, it is not a legal document and has no legal merit. It has to be appropriately filed with the state. In order to do that, it has to be sent in and the filing fee has to be paid. So my understanding of what's going to be happening in the juvenile court is the attorneys are going to be appointed to take care of this, and then they're going to submit for reimbursement what the filing fee is. A copy or a sample of the AOP is included in all the documents with this presentation. Scenario two is that a legal father does exist because an AOP is on file or there's a birth certificate, but there is no existing custody order in on the domestic side of the court. And if that's the case, then the attorney is going to be appointed, usually for the dad, to file a new custody complaint. It's a DC case code. You're filing a custody case only if an AOP exists or a birth certificate is on file. If there's no AOP on file or birth certificate naming that person as the father, you have to file a complaint for paternity, a DP case, so that the court can establish paternity. But primarily in the juvenile end, the juvenile court's going to be ordering the paternity testing already. You're going to be able to attach that to the complaint that you file. Scenario C that you're going to be appointed for is that there is a current custody order in place, generally with mom in the domestic side, and she is granted at least physical custody. Maybe she's also granted legal custody. And paternity already exists by a birth certificate or an affidavit of parent, in which case the dad, you're going to be appointed to file a motion to change custody. And again, you're going to be going through all those best interest factors ultimately in front of the juvenile court. You're also going to start with indicating right where the ECE is and also what the burden of proof is. Again, in a complaint for custody, and all this information is in your packets, paternity, in order to file it as a DC, paternity must have already been established. With a birth certificate or affidavit of parentage, it's required that you attach that documentation to your custody complaint before the judge is going to move forward. All that documentation, those proposed complaints, are found on our website. You have to file all that documentation electronically. Any new filings, the domestic side is not reopening to the public anytime soon. And so if ever, and so everything is now done electronically. The filing instructions on how to do these things electronically are on our website. And everything, of course, you have to serve the opposing side in a case. The case that you filed here cannot get transferred to juvenile court until after a proof of service has been filed with the domestic court. So you start an action, you serve the party, and once we have a proof of service, it's only then that we can transfer that case over to the juvenile court. Proof of service is very important for service. If you have difficulty serving, then you'd be coming to our court and ask for a motion for alternate service so that we can set that up, and then you file the proof of service that you've completed the alternate service. Motions to change custody, those are in divorce cases, paternity cases, custody cases, or support cases. Existing custody order exists, you would attach that to your motion and file that with the domestic court. Again, all those attachments and the forms are found on our website, and the filing instructions are found on our website. In the packet of materials, you're going to find orders, an order for custody, parenting time, and child support. That is what the juvenile court is going to be entering at the conclusion of your custody case. So that is completely filled out. That is entered onto Juvenile Odyssey and Correct, which is what the court clerks do in juvenile. And then a judgment of custody is used. There's both of those in your packets when a new complaint has been filed, either for paternity or custody. Both of those orders that has all the statutory language that's needed is in all the documentation that's attached. Okay, so that completed the portion on custody. We're going to take a few-minute break here, and then I will get to any questions on custody before we proceed with the paternity issues. I'm just going to stop sharing for a moment, and I will get to all those questions after the break. So we'll be back in about 10 minutes. Please don't take any longer than 10 minutes because we have a lot more material to get through. Thank you. Okay, Richard, do you think we're ready to get going?
Sure, Your Honor, go for it.
Okay. So what I'm going to do is just finish up the rest of the materials. There's not that much left to get through from here, and then I will spend as much time as necessary to answer any questions that have already been submitted or any additional questions that you have. Okay, so the next, pull up my presentation. Okay, so we'll go to paternity issues. So previously I had indicated if there's a birth certificate on file or an acknowledgement of parentage on file with the state, then that would be a DC case, a custody case. If there's not an AOP on file or no birth certificate on file, then you have to file a DP case, a paternity case. The P is for paternity, the C is for custody. All of the documents and the complaint for paternity are on this attached website for everyone to download. It's also, I believe, included in the materials that I presented today. And if genetic testing is done in juvenile court, then you attach that documentation to the complaint. Otherwise, at the case management conference set for the domestic court, we would order paternity testing to be done, and that would be at a cost. That's why it's important to get that genetic testing done in juvenile court, because that will be free. Electronic filing is done completely through the family division electronically, and that will stay in place. These things can be mailed into the court, but the quickest and best way to get service and to get your case moving is to file everything electronically. At the time that things are filed, a case management conference date is set. At that point, if there's juvenile and these complaints for paternity, complaints for custody clearly indicate that they're with juvenile cases pending, and that triggers for all of us to be waiting to make sure that service has been completed, and that as soon as service has been completed, we are able to refer those cases over to the juvenile court. What will happen if the GT testing is attached to the paternity case at the case management conference, presuming that service has happened with that DNA testing that's been attached to your complaint, the assigned judge is going to enter an order of filiation, reserving all the issues of custody, support, and parenting time for the juvenile court, and then refer the case over to juvenile court. Again, that's the importance, and that order of filiation is attached to your materials so that you know what that looks like, and you can present that to the domestic judge for that case. Again, we have to have service before we are referring any cases over to juvenile. Okay, the establishment of paternity. If parties are not married, the parties must either, again, file a complaint for paternity or obtain an order of filiation. I would never recommend that a father sign an affidavit of parentage without securing genetic testing. As a presiding judge, I preside over all of the paternity cases where people are asking to set aside the AOP. I can tell you that 50% of the cases that we send for GT testing come back that the father is not the biological father of the child. So again, 50% of the testing we do on our side, and this could be after a child is, and a support order's been in place for many years, etc. So I would never recommend having a client sign an AOP without getting genetic testing. There was a question about, how you're going to get the notary. We don't have any specific site for notary. With the pandemic, there were electronic notaries are available, and you would have to Google that information. I don't have a specific site for electronic notaries. The affidavit of parentage, again, must be signed in front of a notary and by both parents, and then it must be submitted to the state with the appropriate fees so that it can be properly filed. I also have included in there that if no name is on the birth certificate, or the wrong father's name is on the birth certificate, there's an application to correct a birth certificate that's enclosed in your materials. You have to attach a court order, a certified court order, or you have to attach the filed AOP and pay the fee in order to get the birth certificate changed. Just so you understand procedurally what happens if the genetic test is done in the juvenile court. The results of that GT testing is going to be entered on the juvenile Odyssey case, and you would ask for a copy of it there, or you would attach it to your pleadings. Again, you file a complaint for paternity, and a sample of that is attached. If the wrong father is on the birth certificate, the bio dad must file his own complaint or motion to revoke paternity. Your court appointments will not include any representation, because as far as the juvenile court is concerned, there is a legal father, and it takes a motion filed in front of me to revoke in order to set that aside. The Revocation of Paternity Act, again, I just want you to have a knowledge about this. You're not going to be appointed to do this, but I know that this situation occurs with some frequency in juvenile court. The motion to revoke the AOP must be filed within 3 years of the child's birth or 1 year after an order of affiliation is entered. The court can extend that time filing for certain reasons: fraud, duress, mistake of fact, or newly discovered evidence, misrepresentation, or misconduct. We can never correct this issue if the child is over the age of 18, as a court no longer has any jurisdiction over the child. The closer the child is, from 1 to 3 years, you'll automatically get an opportunity to do genetic testing, because it's within the ROPA period, 3 years. After the 3 years, when the biggest ability, the most likely way to prevail on a motion in front of me on this issue is to attach DNA testing evidence that shows that someone else is the biological father. That does show mistake of fact or newly discovered evidence. Those motions are on our court's website. And all of those motions and complaints regarding revocation of paternity all get filed over here in the domestic side. They do not get filed in the juvenile side. If they're filed in the juvenile side, the juvenile judges should dismiss them. They have to be filed here. And as a presiding judge, irrespective of where the other order, which judge the other order was from, they get sent to my Judge McCarthy-Court joint email box. All the judges have a joint email box in our division, and the motion gets filed with me and we set it for hearing. Again, that's not in the juvenile section, it's done in the domestic side. Okay, and then questions on paternity, just give me a second. I'm just gonna go, I'm gonna go right to the child support portion, and then we'll circle back for any questions so it's complete. So if you're appointed to do a motion in which you're going to secure an order of affiliation, a final order of affiliation should include all the provisions for custody support and parenting time. And ultimately, any final order you're entering in the juvenile case to close the case should include custody broken down, physical, legal, parenting time with specificity. Just indicating reasonable and liberal parenting time is not sufficient for the domestic court, because it just causes a motion to be filed on the back end. And it's supposed to include child support. And I know that's a scary word for a lot of the attorneys, but there is, Michigan follows a child support formula. It takes into account the parties' incomes, their child care expenses, medical insurance expenses, and the number of overnights the minor child has with each parent. The formula does not consider a person's living expenses or debts. We always get motions that say, hey, you know, my rent is this and my electricity bill is this, and I've got 5 credit cards and 2 cars, and I can't possibly pay this child support. The child support formula is roughly 1/3 of a party's net income. 1/3 of a party's net income is roughly what the formula will calculate per child for child support. The attorneys are expected to run the child support guidelines. If you're representing the man, certainly you're going to be able to get a year-to-date pay stub for him and put that into the calculation. It goes by monthly income. And for the other side, because they're a part of the juvenile case, often, obviously, if the mother is suffering from some issue, she may not be working. And so her income may be 0. The other side may have, currently in this pandemic, they might have unemployment income. Don't forget about the unemployment income plus the extra $600 that may or may not continue. We're going to find out shortly from our president whether that's passed or not. But you would use all of their income from any source when running the child support guidelines. If for whatever reason, and here's a link in your materials for the child support calculator. It's found online with the state of Michigan under My Case. There's a calculator. You again take the number of overnights in your proposed order. If it's, you know, alternate weekends now for mom, it's, you know, 52 overnights with holidays, et cetera. The court kind of uses a general 75 overnights for what we determine is reasonable parenting time, which is alternate weekends, some holiday parenting time, and some summer parenting time. We use the number of 75 as a basis for the number of overnights. It might be completely different in the situation. You know, it might be no parenting time because of whatever's occurring in mom's home, or none for dad, et cetera. So you run those guidelines and you would attach them. You should attach them to your order for the judge to review. Please keep in mind if there's an existing case that when we refer the case over to juvenile, most of the judges remember to stop current support from cycling. You want to have an inquiry into that. Anybody that has a child support case in the state of Michigan can register their case online and through the front of the court, through my case, and have the availability of their own information. So if there's a significant arrearage that's sitting out there, you want to set support for mom if it's appropriate, so that and ask that support eat away at that arrearage. So if you set it at, you know, $400 a month, but mom doesn't have an ability to pay, $400 a month would offset what the current arrearage is before her obligation would start to cycle. So those are things to think about. Your clients can sign up for my case themselves and get a copy of their report. They can call the friend of the court. All that information is on the court's website. If there's some anomaly that's happening with child support, which I don't know what that would be, but we have provided you in your final order, if it's a referral to the friend of the court for child support calculation, please keep in mind, we have about 1,500 cases backlogged at the front of the court through the pandemic. So it's not going to happen anytime soon. But here's the emails for Dave McPhail for 3RDCC for juvenile referrals, that those orders following entry in the juvenile court can get emailed over to him to set up a, what we call it a rev mod, where they interview the parties and send out a information sheet to acquire their last income so that they can run guidelines. So please don't forget about the child support. And we've provided a uniform support order in the materials. That's what you fill out. That is the document, a uniform support order. To start child support with the state of Michigan, it has to be on that form. It can't just be contained in the order. A separate uniform support order does have to be entered with a commencement date and all the parties' information. If you leave it blank, then the front of the court cannot determine employers, et cetera, and it will just sit there and never circulate. So that's the end of my presentation. I do, and all the materials for the presentation are on the juvenile website. If everyone hasn't discovered that by now, for today, an email was sent out with that information. Under the juvenile section, all the materials for today are there, including the presentation I just went through, and then all the additional forms. In the forms, there's a complaint for custody, parenting time, and child support due to juvenile court proceedings, and it has step-by-step instructions on it. There are all the forms that are necessary to be filed with your complaint, which include a case inventory form, which lets, it's required by SCAO, and that lets, you must list all the prior cases that the family has been involved in, whether those are PPO cases or custody cases or the current juvenile case, should be listed on that form. So, and the reason that's so important is that when the court clerks get them at the filing, they relate all these related cases together. So the juvenile judges can find the domestic information, and the domestic judges can find the juvenile information. There's also what's called the Uniform Child Custody Jurisdiction Enforcement Act. It's required by statute in any case involving a minor child that you list for the last 5 years where that child has been residing and with whom. The form is included in your packet, must be filed with a complaint, and the details on that form are necessary. So if a child has lived at 8 different addresses in the last 5 years, you would list each of the addresses and list the period of time, you know, from January of 2014 to December of 2014. The next address would be the next address and the length of time that child has lived there. The reason for this document is to make sure that Michigan has jurisdiction over a case and that Wayne County has jurisdiction over a case versus another state or another county. There's what's called a verified statement attached. That is, again, a required SCAO form, and all of these forms have to be completed with specificity. There's a lot of information on here, but it's what the front of the court uses to establish a case, start an income withholding, stop an income withholding, and connect children to the appropriate cases that's on file. There's what's called an application for 4D support services. Anytime there's child support in a case, that application does need to be completed for the front of the court to process any payments. There's also information in here for fee waivers. At the start of any case, the attorneys must submit the documentation for a fee waiver first, get that approved, and then attach that to their filing. So the fee waiver information is in there. You have to go through that process first, get the fee waiver approved, get your order back allowing the fee waiver, and attach that with your filing of your complaint or your motion, or it will not proceed. There's also a motion to, for change in custody for juvenile court proceedings. Again, there's pages attached that address the best interest factors. Those do need to be completed with some specificity, and clearly putting the case number for the juvenile case is important to confirm that that case is existing so that we can get it transferred over. That has a similar attachments for fee waivers, case inventory, etc. Those are required SCAO forms. There's an order for custody and parenting time. There's a judgment of custody. If it's a new complaint, the order is used for motions. There is an affidavit of parentage that's included. Again, this form does require it to be completed in front of a virtual notary in this day and age, or there are some banks that are open that usually provide notary services, particularly if either party has a bank account with any particular bank. They provide notary services in person. That's one avenue, or finding the virtual notary services. There's an application to add a father on a Michigan birth certificate, in which case if an AOP was filed, they're not automatically added to the birth certificate until you submit this form and you pay the fee. And then there's a uniform support order, which is where you put all the information for custody. I'm sorry, for child support. Again, this form must be entered and submitted to the domestic court in order for it to be processed and child support to be taken from an income withholding. Okay, so that's done with the presentation. I'm going to stop sharing this information, and then we will get to some of the questions. All right.
Question, the Q&A, is there? We will see similar questions, and then there's more in the middle tab of those.
I don't understand. Okay, they're asking if a fee waiver can be done by mail, and it can be done by electronic submission. And I think it can be done by mail, but you're going to have to wait for the order to come back before you can file everything else by mail. So it's not the most efficient way to mail anything in. The court clerks prefer everything be emailed in to the email instructions that are on our website. All the documentation for today was on the court web under the Juvenile Division Essential Links Custody Training, as Richard has pointed out. One party is asking if you need a custody order if one parent's rights are terminated. You do, and here's why. If you don't have a custody order in place, and then while the juvenile court clearly has the authority to place a child, they don't have any legal documentation to show that the child is theirs for purposes of enrolling in school. A lot of extracurricular activities require some documentation of a parent's rights to have that child. Getting a passport, all the things that happen in the future is the reason that a custody order needs to be put in place, or a change in custody order needs to be filed if there's an existing custody order. You know, giving custody to mom and dad has now been, the child's been placed with dad, or custody's been awarded to dad. You need an order changing custody, or if somebody dies or their rights are terminated, you need an order for the surviving parent to do all the practical things that we do as parents, enrolling in school, etc. E-filing, again, that's the preferred choice for everything in the domestic side. The instructions are on our court web, and it has some specificity as to what you're supposed to do. Someone's asking if the AOP is filed with the state by the court. That answer is no. By statute, the court clerk is supposed to submit that to the state, but on neither the juvenile side or the domestic side has that been happening. It's a party's responsibility to file that with the state and pay the fee. There's a question about accepting a birth certificate. A certified birth certificate should be accepted by either court. We accept a certified birth certificate or a affidavit of parentage filed with the state to, for any custody cases that are being filed. And in fact, they're required. The question is, on the juvenile end, if the court is requiring a custody order to be in place in order to close out the case, when a child has been returned to one parent through child welfare services, how do we assist that parent in filing and being appointed an attorney that can assist them in their current, if their current attorney is not available? I guess I don't know what that means. These are the scenarios that the juvenile court is using this grant money to now appoint attorneys to help litigants file these cases if it will help close out the juvenile case at the end. So again, if it's one of the three scenarios that we discussed early on in the presentation, that's when the juvenile court will be appointing you to file either a complaint or a motion to secure custody at the end, so that they can close the juvenile matter. Ms. White is asking about virtual notaries. Again, I don't have a list of virtual notaries. You would have to, the banks, your local banks do have notaries. I don't know the extent that they have virtual notaries, and you'd have to go online to secure virtual notaries. Ms. Riston asked a question. I'm not sure I understand. The question that says, what if there is an open juvenile matter that we are trying to close out? Again, that's the presentation that a motion to change custody if an existing order already exists has to be filed. If custody is going to be likely given to dad and mom has custody under a prior order, that's the motion to modify custody. If there's an open juvenile case and to close it out, a complaint for paternity or custody has to be filed. That's what the attorney is being appointed to do. Will we be in reimbursed costs, getting certified copies, process servers, etc.? And Mr. Smart responded that the decision as to how costs are going to be reimbursed or paid has not fully been decided, and that they will be submitting further documentation to you all before they start the process, exactly how that's to be done. So the next question by Ms. White is, what if no father has been listed on the birth certificate, but the child is now 7 years of age? Does the court still have jurisdiction for a paternity action? The court has jurisdiction until a child turns 18. It's only at age 18 do we lose jurisdiction. The question is, under the Paternity Act, whether we will set aside an existing AOP or birth certificate for a child of that age. And again, it has to be under one of the factors submitted in your presentation. It has to be fraud, duress, mistake of fact. And if there is a DNA test that's determined over in the juvenile court, then you attach that to your documentation, and that very well may be newly discovered evidence that the court would then set aside that AOP, allowing the bio dad to proceed with an action. I can't tell you if that's going to happen for sure. It does depend on facts and circumstances. There are cases where both parties know that by signing an AOP at the child's birth that they're not the father, but they decide to do that so they can secure state benefits, or they're in a loving relationship at the time and think that they want to be parents together. That relationship breaking down 7 years later doesn't necessarily fit any definition of being able to set aside an AOP. When a person signs an AOP, which is why I said I would never recommend someone to sign an AOP without having DNA testing. Once you sign an AOP, you are waiving your right to DNA testing. You're waiving your right to ask the court to modify anything about that in the future. It's only if they fall within one of the parameters, primarily if the child is under 3. And if not under 3, newly discovered evidence, et cetera, that they didn't have available at the time. A father deciding to be the father, knowing that he's not the bio father, does not give rise as to a motion to set aside. Another question is, what are the court-appointed fees for all of this? I don't have the answer to that. That would be when the juvenile court makes that determination. Question is, are you able in the juvenile court to file a motion to modify spousal support when there is a modifiable judgment of divorce? No. All of those issues regarding modifications of judgments of divorce, other than custody, when a juvenile custody case exists, are always in the domestic relations side of the court. All motions would always be filed in the domestic relations side. Someone's asking how and when we take the training quiz that's following this presentation. After the presentation, a link will be sent to all of you to complete, and you have to achieve a 80%. You can retake it as many times as you need to, and I believe that the presentation will remain open for 2 weeks. Richard was very generous with everybody.
There's some new questions on the open.
Okay, where do I find those?
Right there.
Here?
Yep.
Okay. What case number goes on the motion for waiver of fees? It would always be the case number of the court that you're filing in. So if you're asking to file a motion in a domestic case, or a new complaint, it would always be the domestic case number. All of these documents indicate they have a companion juvenile case, but you use the case number in domestic to file. But on any of your pleadings, you should include both the juvenile case number and the domestic number. Mr. Ramey's indicating that on a birth certificate is not sufficient alone to establish paternity where parents are not married. That's usually correct. They have to file an AOP. If they're married, it'll be a birth certificate. Sometimes the hospital screws this up, or parents misrepresent their status at the hospital to the nurses, but that's something that's taken care of at the hospital. If they're not married, you have to file an AOP. If you're married, you get the benefit of a birth certificate. Is there a reason for a custody order for either parent when the children is born to the parents during their marriage? No, there isn't a reason for a custody order If there's not, ordinarily there would be a birth certificate, and then if there's a juvenile court proceeding, you would have to attach that to get a new custody complaint. If they're married, you don't have to file a divorce. You could file a divorce to adjudicate custody, or you can file a support case, a DS case, in a marital relationship when you're trying to adjudicate custody, or you file a custody case. Any three of those scenarios: a divorce, custody case, or a support case. I don't know when the program is going to start. That's a question for Richard Smart. The next question is, I'm a child welfare supervisor and the current attorney for the parent on one of our cases is not able to provide assistance in filing. How do we assess an attorney that is able to assist? Again, once this program starts, the juvenile judges will be appointing the attorneys. The specifics of that still have to be rolled out by juvenile court. What if a father is named the legal father but never signed an AOP? He now claims he is not the child's father and wants nothing to do with the case. What if the father never signed? If he hasn't signed an AOP and he's not on a birth certificate, he's not a legal father. He's a putative father. He's not a legal father. So if he's under the jurisdiction of a juvenile case and there's not an AOP or if there's not an AOP or a birth certificate, I'm not sure what jurisdiction the juvenile court has. That might be a Richard Smart question or one of the juvenile judges. The next question is, before the pandemic, that's a Richard question. The parents could go to the third floor of Lincoln Hall and sign an AOP. No fees were required because they were waived. Why can't we fill out a waiver of fee for the AOP? The fee comes with filing the AOP with the state. It doesn't come with filling out the AOP. It comes with filing it with the state. So, and there is a fee for that, and the state is not waiving the fee necessary for that purpose. Are attorneys responsible for assisting parents to file a motion for a change of custody if needed? Or do the parents have to file their own? Okay, that's what this training is for. You're appointed, if you pass the test, to assist the parents in filing these motions or new custody complaints. Am I suggesting that every case needs a custody order prior to dismissal of a neglect case? No, only if the party that is part of the juvenile case, if the child is being returned to that party because they've satisfied whatever requirements were at the juvenile case, then no, they don't need a custody order. Nothing has changed. This is only if custody is being changed to the non-custodial parent based on a prior court order, or if the non-custodial parent is now going to be awarded custody. That's when the attorneys are appointed to file new complaints. Does the domestic division use M-file? No, we do not. The only basis that we use M-file is for the summons. Other than that, there's electronic filing with a web, with an email address. You do use the M-file to file for a summons and complaint on your case. Again, those instructions are on our website. Are court-appointed attorneys responsible for assisting fathers to file a motion to change custody if needed, or is their own responsibility to file the motion? Again, if the juvenile judge believes that custody is going to be changed from the current custodial parent to another custodial parent, the father typically, then yes, you're going to be appointed to file these motions and new complaints for the party. And I think I've answered all the questions. Okay, Richard, do you have anything to add?
Well, first of all, I want to thank you, Judge, for taking your time out and providing us the expertise that we need. I do have a couple of housekeeping matters that I want to to share with everyone so that they know how this program is going to be rolled out. First, please, everyone should know that the program doesn't start immediately. There are some conditions that have to occur. Quite frankly, the grant monies have been awarded to us. However, in order for us to be able to receive the grant monies and start spending them for this purpose, we are waiting for a Wayne County Board of Commissioner permission to do so. It has to go before the board. And once they grant us permission to start drawing these monies down, we can start immediately. We did not want to wait to do this training while we're waiting for that permission. It's non-controversial, so we anticipate that it will occur. We wanted to do this training so that we can hit the ground running as soon as that permission is given by the Wayne County Board of Commissioners. So I wanted to make sure that everyone knew that. You will be receiving a Survey Monkey immediately after this. We have IT on board, and they're going to be sending it out to all of the lawyer attendees on this webinar. And it's 10 questions, true or false. And if you don't get 8 out of 10 correct, you can retake it. We're going to have it available for you to take for the next 3 weeks. So I'm even more generous than Judge had indicated. So
way nicer than I would have been on that.
Well, we just want to facilitate this. We want to be able to let the DHHS know that our attorneys have a certain baseline of knowledge and are able to assist the parents in these matters. Webinar material instructions have gone out again. For DHHS participants, see Mr. Daryl Bronner if you can't go onto the court web yourself to navigate and pull those out, but we've sent those out. They're on the court web under the juvenile section. This recording of this training webinar will be on the court web shortly after we conclude here. IT will assist with respect to that, have this training. If you want to go back and you want to see it again because you enjoyed it so much and you want to review it one more time or catch up on some information, it will be on our court web where you'll be able to see this training once again. And we had quite significant participation. We had as many as 172 people at any given time that participated here today. I want to thank everyone for your interest. I'm looking forward to a new approach, and I'm going to turn it over, if he is interested, to our presiding judge for any closing remarks that he may wish to provide.
Really, I don't have anything, Richard. I would just thank everyone for coming. We appreciate your interest in this and helping our families become reunified. Everyone have a nice day.
Thank you, Judge McCarthy.
You're welcome.
I owe you big time.
Yes, you do. All right, I hope everyone found the information useful and informative. And if there's ever a question anyone has specifically of me, feel free to, procedure process, feel free to email me at my email, which is kathleen.mccarthy@3rdcc.org. I hope everyone stays safe and healthy through this pandemic.
Thank you all.